Hi. The next 15 minutes is for you, our listener, as Fred Kuhn explores this issue.
Welcome, Lisa Barrington and Susan Savit. The question that I have for the two of you is, does it matter who is accused? And for example, can a woman be found guilty of harassing a man or another woman? Is it only bosses? What if it's somebody that works for you?
Sure. So discrimination can occur between the opposite sex, the same sex, man to woman, woman to man.
But doesn't it fall under the other laws dealing with genders, that sort of thing, and that level of harassment, or is it all considered sexual harassment?
So sexual harassment comes from gender discrimination of Title VII. So It's a form of gender discrimination. And not only can you be harassed by your boss, or you can harass your boss, technically, and or another employee, or the same gender or a different gender, but witnessing someone else's harassment can also make you a victim of sexual harassment.
When you say a victim, what do you mean?
So the definition of a victim of sexual harassment is if, indeed, under the definition in the EEOC provides, or by a court of the land, that a determination that somebody was sexually harassed is made, they're now a victim of sexual harassment. They're an alleged victim until which time it's determined that they were a victim. And by the way, when a company investigates, they can define that. Obviously, most organizations don't use that word. Going back to, though, what I was saying in regards to gender and what types of genders, same or opposite genders, can harass, is the courts are split on this. So, for example, every court has decided, and it's very clear in Title VII, that you can't be discriminated based on your gender. So all courts have agreed that if a man discriminates against a woman or a woman against a man, that could be sexual harassment. Where the courts are split is if a woman discriminates against another woman or a man against another man. As a former HR practitioner and consultant, it's my opinion that, as there are with almost all laws, as the different courts are interpreting politics, local law, local beliefs, local interpretations come into play. So you'll see the more progressive courts have interpreted that same-sex harassment is harassment under the law, and some of the more conservative courts have not. Additionally, several years back, the EEOC, the Equal Employment Opportunity Commission, issued a memorandum stating that same-sex harassment is absolutely covered under Title VII. That said, it's been put in front of the Supreme Court to make a decision, so it can be made once and for all. Has not been heard yet. I would guarantee you sometime, I'll put my stake in this, in the next 5 years, that the Supreme Court will look into this, will accept the case, and will make a final decision, so we'll have a law of the land. Susan, what are your thoughts?
I agree with everything you said. It's just two things, one of which is obviously the same way that the law of same-sex marriage has evolved, I think is what's going to happen with this gender issue on same-sex harassment. In addition, Lisa alluded to the fact that the EOC has its own rules and regulations and opinions that it fosters on everybody. But from a legal point of view, most courts say that that is something that they are interested in hearing, but they don't have to abide by. So the local mores of the jurisdiction are going to be applied as it has been for years in the courts. There are certain circuits that are more liberal, such as the Ninth Circuit is more liberal, the Second Circuit is more liberal, the Fourth Circuit isn't, that kind of thing. And until the Supreme Court makes a decision on this issue, it's not going to be clear unless and until, again, Congress passes a law that clarifies what the situation is. So essentially, the Supreme Court can clarify it. And if Congress doesn't like whatever they come down with, they could pass a law that vitiates whatever the Supreme Court said.
And to add some clarification to that, Fred, for our listeners, so as an example, the Ninth Circuit involves states such as California, Oregon, Washington. It also involves some more conservative states such as Arizona and Idaho. But what's interesting is it sits in California. That's where the court sits. And the Second Circuit, we've got New York, for example. So you can see where you've got more liberal versus more conservative courts.
Yeah. So it's a hodgepodge. It's a toss-up game right now.
That's why it behooves employers to look to see where their employees are situated, because, again, the law will define whether or not that's considered a workplace. But if you have people all around the United States or in different countries, the law may be different.
Yeah. And I think what I've seen many employers do, including some I've been associated with, in order to keep things simple and afford themselves the greatest protection, is if they operate in multiple jurisdictions, multiple circuit court jurisdictions, they'll look to the decisions of the most conservative court, meaning in this case, the one that's offered the most protection towards employees, and they will, in that case, make their policies related to the most protection. And even in jurisdictions where it's not necessary, it's just simpler to have one policy. In particular with companies where people are on the phone with people in different jurisdictions, visit people in different jurisdictions, it's sometimes easier just to go with the most protection for all.
One issue we haven't addressed, and when it comes to who the law applies to, is retaliation. And I'm sure Lisa has a lot to say on that issue. But essentially, if somebody files a charge, or if somebody stands up for somebody who's filing a charge or a complaint, even if it doesn't rise to the level of actually going to court or going to an agency such as the EEOC or a state division of human rights, if that person is then transferred or demoted or given less opportunities, and even fired, or if that person goes to another employer and that employer's request for you to give them a reference, you say, well, that person was great, but they filed a charge. They have a right to come after the employer in what's called retaliation.
A person who had filed a complaint at Company A and left Company A and applies for a position at Company B, if Company B finds or discovers in the discovery of a process of references, at checks, etc., and they don't hire the person at B because of what happened at A, that's also up for litigation?
They can say they've been retaliated against.
How do you prove that?
My job was to disprove it most of the time. But essentially, what you're going to do is request documents, and such as what you hear going on in, the television nowadays where they're requesting documents. And you'd be surprised how often people gratuitously put comments down on something. I spoke to George and they said that Susie filed a charge. And that's going to be in that file. Or somebody's going to write a reference letter and it's going to say something in it. And I'm sure Lisa has tons of stories about these kind of things, because no matter how much you try to explain to people, somebody inevitably puts something down that I, as the attorney, either on either side, are going to be looking for, and it's the smoking gun.
But if you had, like, for example, in our company, when we're in our retained search division, I always have done 13 reference checks. I got 13 questions I ask of multiple references. And if one out of 13 came with a, well, I know he filed a suit or she filed a suit back here in 1999, and it's only one, but everybody else is also saying, well, she's good at this, she's good at this. And we evaluate that and make a determination as an employer, let's say, not me, but on behalf of the employer, I look at it and say, I pass that information on, and the employer looks at it. If it's generally a blasé recommendation set, is the employer stuck because there's one statement in there and they don't hire the person, then they can be sued if it appears anywhere? Or how do you judge an overall evaluation of an individual? Because you're bringing them in to play well with others, you're bringing them in to exceed value proposition, expectations, those sorts of things. How do you deal with that?
I think, let's assume, somebody's looking over the whole process and they've got, like you said, 10 recommendations, all of which are great, and one of which says, well, this person had a problem. And you have to make a decision. I think you've got to be sure you've got your ducks in order. So if you refuse to hire this person, you've got to come in with a employment-related issue on how this person could or could not do the job. You need some other reason for making the determination negatively. And that's going to have to be a good one. Not one that's just been made up, or the court's going to think it's been made up. So you don't have to hire somebody, but, you have to have a good reason not to.
You have to cover yourself to make sure you don't get sued. It's getting more and more complex, I used to do business with people on a handshake. Now it requires a 20-page contract.
Yeah, well, that's why And I'm not sure I necessarily agree with it because you end up passing bad employees around. A lot of lawyers will tell people, don't say anything other than this person worked for me from X to Y and made a certain amount of money, and this was their title.
Right.
And we'll not give any other information.
Doesn't that have to be a published policy in the company, or it has to be applied to every employee that was there, right?
Yes, it has to be applied across the board.
Right. Okay. What a great discussion. Thank you very much, Lisa and Susan, for these wonderful insights.
Thanks for joining us. If you wish to speak with Fred or you want a transcript of this interview, send an email to podcast@stuartcoopercoon.com. See you soon.